We are lucky to have Joan McMenemy here with us today. She's the first justice of Berkshire Juvenile Court, and she's going to talk a little bit about a day in the life of a Berkshire County judge. So I will hand it over to you, and thank you again. At the end, if anybody's interested, we also still have tea and coffee available for you, so enjoy.
Sure. Thank you so much.
Thank you.
And actually, if you'd like tea or coffee, at any point, please help yourselves. Welcome to our gathering. I'm Judge Joan McMenemy, as you heard Michelle say, and I am the lucky first and only justice of the Berkshire Juvenile Court. I am the only judge assigned to the Berkshires full-time for juvenile court work. So, and I have held this position since 2010. In Massachusetts, you know how judges are appointed in Massachusetts? Lottery? No, it's not a lottery. It's, yeah, they just... Yes.
So I'm not positive that is the usual way, but I remember that he did appoint.
Yes, and that's ironic. That's who appointed me. Was then Governor Patrick in 2010 appointed me. And yes, I do feel I am very, very lucky. So I was just saying I'm very happy to be here today. And if at any point during this little presentation, if you have any questions or any thoughts, please feel free to ask. This is a casual and informal gathering. Judicial outreach is an idea, a concept where we realize that we sit in our courts and we wear robes, and in my court, it's all secret. You don't get to come in and watch, although there are courts in this county that if you did want to go and spend a day in court, you'd be welcome to do so. Sometimes the public doesn't know really like what we do, and in particular in juvenile court, right? And we sit in our silos, and it's nice if we can kind of get out sometimes and talk to folks and explain what we do, what goes into a day, in the life of a judge, so to speak. And it might help just to put some things in context to know that I've lived here in the Berkshires for about 30 years. I moved out here in 1994 for when I got out of law school. I graduated from Suffolk University back in 93, and I wanted to work in the district attorney's office. And at that point, Jerry Downing was the district attorney out here in the Berkshires. And I put out applications to all the DA's offices in Massachusetts. And back in 1994, he was one of the few that were hiring. So I thought, I'll take a ride to the Berkshires and see what's the story there. And I drove through your charming town of Lee and up through, and I thought, wow, it's so pretty out here. And I'm from Worcester. So I really hadn't spent much time out here in western Massachusetts. Worcester will come back, I can assure you. And I thought to myself, as I was leaving the interview, oh, what a shame that it's such a pretty place. I'll have to remember to come back out here sometime for vacation. But then Jerry offered me a job. I took the job. I moved here from Boston, and I was going to stay for a couple of years. And now here I am talking to you all. So that's how that worked. I worked in the district attorney's office for about 16 years. I started in district court. I was a prosecutor in juvenile court. I was put in superior court at a certain point, became chief of the child abuse and sexual assault unit in superior court. I did a number of years where I was the prosecutor, so to speak, the assistant district attorney in juvenile court. And I realized at that point, and as you can imagine, it's a little bit of a different court than, say, district court or adult court in terms of, the approach to cases and even your approach to being an assistant DA. And I really enjoyed being in that court. I enjoyed appearing before Judge Parachi, if anyone remembers that name. He was the very first juvenile court first justice in the Berkshires. In 1996, the state really pushed to create a separate and distinct court system in every county for juveniles. Because prior to that time, juvenile court cases were handled by the sitting district court judge, usually in the judge's lobby, okay? Often one afternoon a week, sometimes one afternoon a month. They'd have the kids come in, go into the judge's lobby, and have a case. There really wasn't like a defense attorney. The proceedings were not recorded. And there really was a push in Massachusetts to create a court system that ensured special attention would be given to juveniles, but also confidentiality, but also due process rights, right? Have the right to counsel. For example, if you're charged with a crime and breaking the law, you probably should have an attorney appointed to represent you. And whatever happens to you in court, we should probably record it so that there's a record of what happened in court. So since 1996, there's been a separate juvenile court. I sit in Pittsfield 5 days a week. There's a North Adams session as well. We used to have a session in Great Barrington 2 days a week. After COVID hit and everything went to Zoom for a little while, we stopped going on a routine basis to Great Barrington, but I still do go down there when a case requires. But as many things in Berkshire County, sometimes you have to travel to court, right? So, but if there's ever an issue with transportation, we can accommodate that and meet in Great Barrington. I loved juvenile court when I was at the DA's office, and when Judge Parachi announced his retirement, I applied for his job. And I'm very, very lucky because it was the first time I'd ever applied for a judgeship, and I was lucky enough to secure the approval of Governor Patrick. Just so that you feel a little bit perhaps knowledgeable or better about how judges are picked, you should know that we have a really good system, I think, here in Massachusetts. And I think it's good not just because they picked me, but also because there's a lot of systems of checks and balances that go into the process of selecting your Massachusetts judges, whether it's juvenile court, district court, superior court, probate and family court. There are requirements, like with all things, where you have to be an attorney for a certain number of years. And again, the application is a lengthy application where you need to provide information about the cases that you've handled, the attorneys that you've worked with, the judges you've appeared before. So the name of the litigants, a summary of your case, what were the 5 most significant cases of your career, and it just goes on. And the reason the application is so extensive is so that the people who are vetting them can reach out and talk to every single person that you've ever dealt with. If you're a prosecutor, they want to talk to the defense attorneys that you dealt with. They want to talk to the judges you appeared in front of. If you're a defense attorney, they want to talk to the prosecutors and the judges, and because they want to get a sense of what was this person like when they were a lawyer, a litigator. Were they fair? Were they ethical? Were they underhanded? Were they hardworking? Did they show up? And what's their general demeanor, right? Because it's important that they try to pick people that have a judicial demeanor if they can. And so after the applications go in, there's a group of people that get appointed by the governor, and they're called the Judicial Nominating Committee or Commission or Committee. I'm not sure. We'll edit this out at the end of this presentation. The JNC is what we call them. The JNC, I think there's 20 some odd people on this JNC committee. They meet routinely. They review applications for judgeships. They decide who to give interviews to. And then when they bring you in for an interview, and I'll tell you they brought me in for an interview, there were probably 22 people around a table, and they give you a 20-minute interview. You come in, they fire questions at you. You don't even remember what your name is or what you just said. In the 20 minutes, it happens so fast, and then that's it. They move on to the next. But it's just to kind of see, I think, if I can be so bold, it's a little bit about getting a sense of who you are, but how do you handle pressure and such. If they think you're a viable candidate, they then put you to a process called due diligence, where someone is assigned to check into you and make phone calls and talk to people and find out what they think about you, and it's confidential. You can be candid. I get calls sometimes from the JNC about judicial candidates now, people that may have appeared in front of me or that I knew when I was a lawyer, and that process goes on for a few weeks. If it looks good, the JNC then might recommend to the governor's office that this is a viable candidate for an open judgeship, at which time the governor's lawyers take a look to see if they think this is a viable candidate. And there's another group, they call them the Joint Bar Commission, and they're made up of representatives from all the bar associations in Massachusetts. And they take a look at the applicant's credentials and can do due diligence and make phone calls and check into things. And if the governor then is still thinking that you're a viable candidate after all these background checks, they do have the state police do a thorough background check. And this is where, again, on your application, of course, you're disclosing all kinds of information, your financial background, your your family, and they do a very deep background check there to see if, when I check the box that said I have no prior criminal record, is she telling the truth? Is she full of baloney? They check into your financial background. They want to make sure you're not, again, just not being truthful on your application, and that you've lived a pretty, again, lawful existence in your life. And then after that background check, the governor may offer you a position. And you think, oh, gosh, that was so, after all that vetting and now that all the hard part's over. But really, the hard part is about to begin, okay? Which is, you go before a body in Massachusetts called the Governor's Council, okay? And we have a local, a North Adams representative on the Governor's Council. First time in my professional career that we've had someone from the Berkshires on the Governor's Council. Her name is Tara Jacobs. Tara Jacobs is available to all of you. Tara Jacobs will take your phone call if you have an opinion about a judgeship or a candidate for a judgeship or what have you. That's the kind of Governor's Counselor she is. And then at the Governor's Council level, they meet a couple of times, I think they meet a few times a month, and they, once again, interview and vet judicial candidates. And that's really your confirmation hearing. They gather information in the background. You have a public hearing in Boston. And kind of like when you see confirmation hearings for federal judgeships, and it's the Senate, Judiciary Committee, maybe candidates for the Supreme Court, for example. They have these public hearings, Senate Judiciary hearings and such. The Governor's Council in Massachusetts performs that function. So it's not our state Senate and it's not our House of Reps. It is the Governor's Council. And the Governor's Councilors are once again elected by all voters. It's important to know what the Governor's Council does, but I have to be honest, before I applied for a judgeship, I had never heard of them, right? As a voter, how do I not know who the Governor's Counselor is in my county? We got to be, again, we talk about civics and whether or not they're teaching it in school, and our kids today tuned in to government and the branches of government and the importance of voting and how to get involved. But Governor's Council is a very important position, and it's an elected position. So the Governor's Counselors, there's 8 of them. We usually pick odd numbers because when there has to be votes, there needs to be a tiebreaker. The Lieutenant Governor breaks the tie if there is a tie. And by a tie, I mean they either vote to approve you or to reject you. And in the end, you have to have a majority. So if 4 Governor's Counselors say this candidate is good and 4 say no way, the Lieutenant Governor would break the tie one way or the other. So, and I was lucky, again, I made it through that process 6-2. Now, if I wanted to leave this judgeship and say go to the appeals court or a different court, I'd have to go back to the Governor's Council, and my family's all like, nope. And this is the thing. I had a hearing where, again, I was in the DA's office for 16 years. And people, it's a public hearing, and it should be a public hearing. And it was announced in the newspaper here in the Berkshires. I'm sure you remember it. I'm sure you cut it out, just like my mom, that, this person's up for a judgeship, right? And here's when their hearing is. And so people can come and speak in favor of you. They can come and speak against you. And then, as you may probably be aware, sometimes these hearings can sound political. And things... sometimes, again, in my humble opinion, at my hearing, get blown out of proportion. But in any event, I was a 6-2 confirmation. The Lieutenant Governor didn't have to come in and break the tie. And so I became a judge in 2010. Okay. And this is where I stay. And I love my job and look forward to retirement. And you can have both, right? You can have both. I can retire in 5 years. So 15 years I've been on the bench, and I think probably at about 20 years I'd say it's just time to do something else, right? So a juvenile court judge juvenile court in Berkshire County, it handles what you imagine it would handle, juveniles. It's in the name, right? Juvenile court. So anyone under the age of 18, between the ages of 12 and 18, who's alleged to have violated the law, they would come to juvenile court to have their case heard. They're appointed an attorney. There's a prosecutor there. There's due process of law. the prosecutor has to provide their attorney with all of the information, we call it discovery, that any defendant would be entitled to, what would be used to prove the case. I, as the judge, would decide things like motions and, were there any constitutional violations of this juvenile's right as the police were investigating. Once the juveniles have counsel and all the discovery, they confer with their lawyers. Should they try to resolve their case short of a trial? Do they want to exercise their right to have a jury trial or a bench trial here in Massachusetts? Or are there other motions that should be filed? And I sit in Pittsfield, like I say, 5 days a week, but on Mondays I tend to handle delinquency cases, okay? I actually give folks time slots. I love a schedule, and I like to keep that schedule. I don't say to everybody, come to court at 9 and sit here for 5 hours and come back this afternoon after lunch because we didn't reach your case. No. This is not, I don't want to slam the registry of motor. They're much better. The registry is much, much better now. They really are. They've actually got a great system. Let's call urgent care. Like, where you go and you sit for hours and you don't know when your case is going to go. No. After COVID, and we had to give people slots on video at times, I realized, we can do this all the time. So your case is on at 9, you're 9:15, you're 9:30, you're 10:45, you have 2 cases. You're 11 o'clock and you're at 2 and you're at 2:30. And the idea is that you can, come to court and pretty much be heard very close in time to the time you were scheduled. And that just makes everybody, including the court officers, a lot happier. It's always nice to have happy court officers, I'll just tell you that. It's not my primary goal, but it's a happy byproduct that they don't have a packed lobby of angry people waiting to have their case heard. And ever since COVID, it has come, it's an important thing to try to minimize unnecessary exposure, with a bunch of people sitting around. And guess what? In my court, there's a lot of kids there, and kids go to school. And the other thing is that a lot of parents work. They have to miss work to come to court and sit there all day. Oh, no. And maybe they can take a break or at least take a half a day off from work, or even better, go to work after, especially if you have one of the early morning cases. And I always say to the kids, where are you going now? I'm going to school. That's the right answer, right? Because that's where they should be going. Minimize that time at court. That was one of our goals, and we're able to do that pretty effectively. Juveniles in Massachusetts, generally their proceedings are confidential. However, in 1996, when they created the big juvenile court system, around that same time, there was a case in Boston where a person who was under the age of 18, and I don't remember his exact age, maybe 14, maybe 15, last name O'Brien. It was in Somerville, Massachusetts. He killed his next door neighbor, this juvenile. He stabbed her many times. Back in those days, the law said that if you want to try a kid as an adult, the juvenile court judge will hear what they call a transfer hearing. And what has to be presented is their probable cause that the youth committed the offense, and can that youth be rehabilitated within the juvenile system? In other words, before their 18th birthday, can they be rehabilitated? And in that case, the juvenile court judge who was hearing the case found that the kid could be rehabilitated as a juvenile. And the legislature responded by saying, actually, we would like the district attorney's office to control whether or not someone has access to adult penalties. Because that's if you get transferred as a juvenile back in the olden days, you were transferred to adult court and subject to adult penalties for whatever the offense was. Only certain types of offenses, could you have a transfer hearing. Murder, serious felonies, sexual assaults were subject sometimes to transfer hearings. So they changed the law in 1996. So if the district attorney's office thinks that a juvenile should have the potential to be sentenced as an adult, the district attorney's office can take that case to a grand jury. Grand juries meet monthly here in the Berkshires. They meet 3 days a month usually. And a district attorney's office presents cases. Grand juries decide whether there's probable cause to charge people, and if so, with what? What's the crime they should be charged with? And it's a group of people just like yourselves, a big group. I think it's 20-some-odd people. I can't remember now. That was so long ago. But it's a group of people who have to come in and listen to all the cases. I used to love presenting to a grand jury. It was always kind of fun. And I'm sure they loved it too. Some did. Some clearly, it was a very eye-opening experience, I think, for some folks. And in any event, back to the juvenile thing, the law changed. And if the DA takes a case to the grand jury, presents it of a juvenile who's 14, 15, 16, or 17, and if they commit a certain type of felony that has the infliction or likelihood of serious bodily harm, or is a certain gun offense, or they've previously been committed to our Department of Youth Services and it's a new felony, something serious, the DA's office can seek youthful offender status on this juvenile. And what that does is if they come in as a youthful offender, the juvenile can be sentenced to technically what is considered a juvenile penalty, or they can be sentenced as an adult, or they can get what we call a combination sentence, where they're sentenced to a commitment to our Department of Youth Services plus an adult penalty that's suspended and kind of hanging over their heads, and they're on probation for a while, and if they stay out of trouble, that adult sentence is never imposed, but if they get back into trouble, the adult sentence could be imposed, okay? And I should tell you, importantly, the legislature in 96 changed the law to say if it's alleged that a juvenile committed murder, they never come to juvenile court. They go directly to adult court, and they are prosecuted just as any other adult would be. You get arraigned in district court. The DA's office usually then takes the case to the grand jury. If you are indicted, there's probable cause. Your case then is taken to Superior Court. In Massachusetts, Superior Court judges have the authority to sentence people to both House of Correction sentences, that's our local county jails, and also state prison, right? And that's state prison usually for serious felonies. Every crime in Massachusetts, for the most part, has a potential penalty. Sometimes it's a fine, but for the most part, there's a range of time, not more than 2.5 years in the House of Correction. That's a misdemeanor, anything that's just House of Correction only. But then there's felonies, things that it could be a House of Correction sentence or a state prison sentence. And for the serious felonies, those tend to go up to Superior Court, and a Superior Court judge hears the case. Our district court judges tend to hear a combination of misdemeanors and felonies, but their powers only go to sentencing to House of Correction time. So if the DA's office is looking to send someone to state prison for a potential penalty, they have to indict it and get it to Superior Court. In juvenile court, if the youthful offender case comes before us, we have kind of like these hybrid powers of sentence them as a juvenile or as an adult, and state prison, is on the table. So if you're asking, and I hear someone ask, Judge, have you ever sentenced someone to state prison directly? I have never in my career so far sentenced a juvenile to a straight adult state prison sentence. I have sentenced combination sentences, which is, again, a Department of Youth Services commitment to age 21, and then an adult sentence hanging over their head for a period of time when they get out of DYS that never gets imposed as long as they stay out of trouble. Certain crimes have mandatory sentences, and they kind of tie the hands of the judge, the sentencing judge. So, for example, certain drug offenses have mandatory sentences. There are certain sexual assaults that have minimum mandatory sentences. But in any event, these are the sentencing options that are open to me when I'm handling youthful offender cases. The other thing that's weird that you might not have known is that youthful offender cases are open to the public, so anyone can come in. Usually juvenile court proceedings are closed, but if it's a youthful offender status, the press can come in, the public can come in. How many times have I had the public or the press come into a youthful offender case in 15 years? Once, maybe? Because usually people don't know about it. And I'm not trying to promote it here today, but hey, I got a case next week. No. So for the most part, I can't talk specifics about any juvenile court case except for youthful offender cases because those are open to the public. If you have any interest whatsoever, you can go to district court or Superior Court. And I think it's kind of interesting, but, I'm weird that way, to sit and watch court someday. I wish classes, as long as it's not too difficult a case, would go and watch court someday, see what the judge does. It's fascinating. And when I say it's fascinating, it's why they make TV shows about it, right? What do they make TV shows about? Hospital dramas, courthouse dramas. It's because it's always something. It's always something. And every day is different. And that's why I do love my job, because every day is different. It just is. Yes, ma'am.
Lots of repeaters.
Repeat offenders. I'll tell you the honest truth. Most people come to juvenile court once. Yep, most come once. But we do have some repeat offenders. The idea, of course, is that we're a court of rehabilitation, right? Juvenile court is trying to rehabilitate the person so that they avoid future involvement with the court system, police, and the adult system in particular. And sometimes we have great success, and sometimes we do not. And it's never a joyous thing when I read in the paper that a 19-year-old is charged with something particularly serious, and I say, oh, I know them, and I know how hard the probation officer worked with them, and I know how devastated their parents must be, and this is just, but sometimes, again, life gets in the way. In general, I can tell you, I feel very strongly like the Berkshires is generally a safe place. My mother always said to me when I worked in the DA's office, and now, I had no idea there was that much crime in Pittsfield. And I said, Mom, there's crime everywhere. If you don't work in the court system, though, you tend not to hear about it. And most of the crime, and even most of the violent crime, seems to be committed by folks who know each other, like within families. There's very little stranger on stranger violent crime, as I would always call it, in the DA's office. When we have it, I can tell you that I feel that the district court and superior court judges, when it's appropriate, when proven beyond a reasonable doubt or an admission, they take it very seriously. They take everything seriously. But our jobs are very different. We're all pals. Like I admire and I like spending time with and having lunch with the district court judges, the superior court judge, probate and family court, housing court. But we all have very different jobs and different clientele. We share attorneys, but we have different jobs. The other thing that's not in the title, Berkshire Juvenile Court, that you may not know is that I also handle all the, what we would call child protection cases. So when DCF is involved with a family and feels that a child's in imminent risk of serious abuse or neglect and that there's no further provision of services that can keep that child safe, they file a case called a care and protection case in Massachusetts. They call them different things in different states. But here it's a care and protection case. As a juvenile court judge, we have those are the cases that we handle. In probate and family court, they tend to deal with things like divorces and guardianships and custody battles and things like that, where the state is not involved. It's, when love goes wrong, it go wrong sometimes. It's really those types of conflict that they hear in probate and family court, along with probating estates and things. But if the state's involved and they have separated a child or children from their parents and stepped in, that's when the juvenile court has the jurisdiction. In my court, just like all juvenile courts across the state, everyone is entitled to counsel, right? If you lose custody of your children, you should have an attorney. If you're eligible for court-appointed counsel, we appoint counsel. The children get a separate attorney, okay? The Department of Children and Families has an attorney. There are times when I have a case where there's many children in one family. There's a couple of different dads, usually only one mom. I might have a case where I have 4, 5, 6, 7, 8 attorneys. If the children all have the exact same position, whatever that position is, they want to go home or they want to stay where they are, they can all have one attorney. But if the children have different positions, I'd like to go home, I'd like to stay where I am, etc., they each get separate attorneys because an attorney can't be conflicted. They have to just represent their client's interests, right? In criminal courts, sometimes people will say to a defense attorney, I don't know how you do it. I don't know how you represent a guilty person, right? But they're entitled to due process. They're entitled to a vigorous defense. If we didn't have the vigorous defense and the due process of law, power could run rampant. These are very important systems of checks and balances. And in a similar vein, in the child welfare arena, the children, the parents, department, they all have to have good representation, right? Or there could be abuses of power. There could be big mistakes made. We want to prevent harm. We don't want to see any child abused or neglected in their house. You also have to, keep in mind that the children love their families and want to stay and don't want to be removed per se, right? And you have to weigh and balance like the cost to that child of being disrupted from where they are, leaving their room, their house, everything they know, being placed hopefully with family, because that's in Massachusetts, in most courts, that's the first order of business is find family, but if no family, into foster care, right? If no family is available, or friend or teacher or someone. And that in and of itself can be very traumatic for a child who might be suffering trauma from something going on in their house as well. So the delicate balance is trying to figure out, is what's happening at home good enough, safe enough, but needs work, or no, we've crossed a line into unsafe and the child needs to be somewhere else. So those are cases that really occupy my Tuesday through Friday. I do delinquencies largely on Mondays, and Tuesday through Friday I'm a care and protection court. We do parents when they're separated from their children. When DCF removes children, they have to come to court within 24 hours to seek court approval just of that one action. They submit affidavits explaining why they did what they did, and a judge is supposed to vet, was this appropriate? If it was on the papers appropriate, we then schedule the case for a hearing within 72 hours, and that's 3 days, right, to get everybody lawyers and prepared to have a hearing if the parents want a hearing or the children want a hearing on the issue of, was this custody order to DCF an appropriate order, or no, the evidence doesn't support that, the children should be returned home, or the removal was appropriate at the moment, but there are things that could be put in place to mitigate the risk, right, conditions and such that a custody order could be returned to the parents and the kids returned home, but with certain conditions, right? So these are the things that folks have attorneys for and we have hearings for. Now that's, again, on the books. 72 hours is the custody hearing. And I'm going to tell you that one of the hardest parts of the job that I hate the most is that we don't have always enough attorneys to take the cases within 72 hours. So it sounds crazy, but we seem to have an attorney shortage. And I know you might not have been feeling the suffering of that, but yourselves. But I don't know where the kids are, like coming out of law school. Do they not want to practice child welfare law? They don't seem to be moving to Western Massachusetts. And as a result, I know that my court has a little, I would say a minor or small problem with not enough attorneys. And we try to fix it by keeping some of the hearings on Zoom so we can steal attorneys from other counties who don't want to drive out here but have no problem appearing on Zoom. Our computer systems and pretty much the Wi-Fi, especially in Pittsfield, works exceedingly well. And in the beginning it was bumpy, don't get me wrong. When COVID hit, March 13th, 2020, last normal day, as I call it. So that Monday shut down 2 days and then opened up on Zoom. And actually, I'll tell you, I'm sorry I jump around, but the first week of COVID, once there was a shutdown, we did custody hearings with 2 phones on my bench, all the lines being used, okay, and that, reading the book, trying to figure out how to do conference calling, and oh my goodness, courtroom recording the proceedings, all the attorneys and the parties on the phone, and I felt like Lily Tomlin. Hello, like that skit, right? Are you the party to whom I am calling? And that's how it worked for the first week. But the trial court got us onto Zoom pretty quickly. I'd never said that word before. Now I say it every day. Do you have the link? Do you have the Zoom link? What a lifeline it was. So we had a system called the Polycom system where we could put a TV in the courtroom and and look at it, but dust it. But then when this all hit and we had to Zoom, suddenly that Polycom machine became a lifeline. And so it was bumps in the road, to be certain. Lots of instructions to attorneys about, you need to make sure that you're not just dressed from the waist up, but you have to be wearing something down, that sort of thing. Instructions to parties like, you can't take the phone into the bathroom. There's no smoking in court, so I'm going to have to ask you to put that cigarette out even though you're home. No vaping. I'd see people dip down below and then come back up. And I'd be like, there's no vaping in court. I can't, but I myself got bold about drinking coffee. I never had coffee on the bench before, but on Zoom I had a cup of coffee. So once we worked out those bumps. So now we still use it. We still use it to, especially when we have cases and hearings that really only take 10 or 15 minutes. And a parent used to have to take the whole day off, sit in the courthouse wait for hours for their case to be called for 10 or 15 minutes. They missed work. They don't get paid time off. It was just terrible. So now we also give everybody slots. We call their case very close in time to the time that you've been given. You can take a 15-minute break from work, a 20-minute break. Do you need me in the? Oh, did I hit my microphone? No. Okay. You can take a break, and we can get you into court. But the other benefit is to steal attorneys from other counties. So I have attorneys from the eastern part of the state, central part of the state, who do appear in the Berkshires to make sure we have enough attorneys for people so they can get their hearings in the time that they're supposed to get them and be represented by counsel and know what they're doing. Representing yourself in court is it's not impossible, but it's a difficult proposition. Yes, Michelle?
So how many cases are on an average day then?
So it varies. And I will tell you that, back pre-COVID, the Berkshires would average maybe like 130, 140 new care and protection cases every year. Divide that by 12, that's like 10 cases a month, right? Divide a month, that's like, I don't know what that is, 2.5 cases a week or something. And that was a lot. I will tell you that since COVID, we haven't ever gotten back up to that level, but we were averaging more closer to 100 new cases a year. So that's less than 10 cases a month. I will tell you last year, and don't think I'm not busy because I am. I promise you I am. But we have docket numbers, and so that's how I know how many cases we had in 2024 because the highest number was closer to 80. These are, I would say, good things, right? Having fewer care and protection cases are good things. But you have to be concerned as citizens and this judges as well that, well, is it because we truly are having fewer cases of abuse or neglect or there are fewer cases reported? Does the Department of Children and Families have the appropriate resources to make sure that kids are safe from abuse or neglect? And I don't know if the process, but generally cases come into DCF because somebody files what they call a 51A report. It might be a citizen, like the average person. It could be a mandated reporter, teachers, doctors, librarians. Are you a mandated reporter? You got kids running around here, right? Yeah. No? Okay. I'll have to ask. My sister's a librarian. I should ask her. So police, and they file 51A reports. When police respond to the scene of a domestic abuse, where parents are, in it to win it, fighting, maybe physically, etc., and there are children present, the police have to file a report with DCF. DCF has to go out and investigate the welfare of those children. So we want to make sure that they're not the department's not over-filing cases, but we also want to make sure they're not under-filing cases. And, so we press on. Anyway, and my job isn't to go out and find cases, but more so to try to sit on and adjudicate the cases that are brought before me, try to figure out custody orders when it's appropriate to keep kids home with some parameters, a little bit of a safety net, and to separate only when it's necessary for their safety. They're in imminent risk of something serious abuse and neglect. So that's the beginning of a case. How does a case end? Well, sometimes most of the cases resolve by way of dismissal. The goal of every case is reunification. DCF has to provide an action plan, recommended services, and parents have a right to trial before anyone can say their child is in need of care and protection. But the vast majority of cases settle by way of dismissal. Things get better. Circumstances change. Kids go home or weren't separated, and cases are dismissed. But for those that can't come to a settlement, we have trials. So I sit on trials where the Department of Children and Families bears the burden of proof. Just like in the criminal realm, the DA's office bears the burden of proof. The state has to bring the witnesses and present the evidence. In these child welfare cases, DCF has to bring the witnesses and the evidence. Because they're civil cases, they can actually call the parents or other people, the social workers. They could call police officers, doctors, and daycare workers. They can call civilians with firsthand knowledge of whatever's going on. And we also appoint an investigator. The court has access to an investigator to also do their own independent investigation separate from DCF. So there's a lot of information that we get to try to get to the right decision. Because what we do, again, is confidential. You sometimes might hear about a case, and those are the cases that kind of tend to blow up in the media, And you might hear, well, there's no statement from the juvenile court, or there's no statement from the department. There are confidentiality laws that bar the department from responding, or the court. And those cases usually involve some tragedy, some really just terrible set of circumstances. I'll just say this: it's, child welfare work is hard work, and maybe that's why we don't have a plethora of new attorneys going into it. I know the ones that are in this field, both for the parents and the children and the department, they're hardworking people who are trying to get it right. But even when you try, you don't always get it right. So so that's what I do Tuesday through Friday as a Berkshire County judge. We also take care of cases where a parent's struggling with their kid, usually a teenager, usually not following the reasonable, lawful commands of the parent. They might be staying out, hanging out with the wrong people, not going to school, using marijuana, any number of issues. And the parents might file a case with my court saying, hey, my child might require assistance. Our goal there is to try to figure out what this child needs to be successful and get this case dismissed. And the vast majority of child requiring assistance cases get dismissed with no adjudication because they just needed something. I inherited from Judge Parachi a series of programs that he worked along with other community-based, artistic groups, and I'll say Shakespeare and Company, the Clark Art Museum, the Barrington Stage Company, Berkshire Medical Center, to come up with some alternative programming. When a kid gets in trouble, there's a lot of folks who say, lock them up. And, well, that might teach them a lesson. They always say that, but it also teaches them some other things that they learned out in Springfield. But there's been a movement away from that mentality of, listen, they just need punishment. And one of the things they need, usually the kids that are in juvenile court need a lot. They do. Probably most of the kids that come to my court aren't kids that were, as you hear people say, they weren't born on third base, right? They were born way back, right? They're struggling to get to first base. They might not have access to, again, just the things that a lot of us were lucky enough to take for granted growing up. Routine medical and dental care, 3 meals a day, a quiet place to sleep at night, a bed, things like that.
Jimmy?
Yes.
So I was lucky enough to take the mediation course by the field court department.
Yeah.
And we did all kinds of scenarios. Sometimes the juveniles would do something wrong. So does the juvenile court not get involved with it? Because we did all these scenarios where, a juvenile broke somebody's window, and then it gets sent to the mediation people,
Yeah.
which is us, and which I haven't done yet. I just took the course.
Yeah.
But it was really great to be able to do that.
Yep.
So do you deal with mediation or not?
No. So if mediation fails, I imagine that the case might come to juvenile court. And this is, again, it's like your approach to juvenile justice, right, has changed and evolved since 1996. And there's a large body of people in research that would promote the notion that it is better if you can solve this by mediation. It's better for the kids not to come into juvenile court because when they come into juvenile court, they may feel like they are a criminal, that they want to see if we can just resolve the problem, quite frankly, in a less formal way. And over the years, whether it's us, whether it was the district attorney's office or what have you, or the police agencies, there's been a big push for diversion where the DA's office has a diversion program. A kid gets charged, and it's usually something like that. They broke a planter, messing around doing something. It's not cases where there's someone who's been seriously injured, felonies, things that are pretty serious. But these misdemeanors, the stuff that kids do, not me, not you, but other kids, and just the kind of knucklehead stuff that just poor decision making.
So it doesn't, before it gets to you.
Yeah.
And this mediation process is going on.
Yeah.
Who decides? Because I'm confused a little bit.
It'd be the police usually, or whoever. Yeah.
You want to go to mediation?
Yeah. Yeah. Usually the schools or the police, right? Because a lot of stuff happens in schools between two people. There might be a fight. Or the police have, some, they get called, something got broken, right? And the police have choices. They can file a charge in juvenile court, At that stage, they can ask that a clerk magistrate have a hearing. And if they find probable cause, hold it at that stage. Don't bring them into court. And as long as they stay out of trouble, pay restitution, write a letter of apology, whatever the conditions are, it will never come into court. And that used to be the old-fashioned mediation, but now there's even more of a push to say, let the district attorney's office do it, or let community members, if there's some sort of restorative justice or mediation board, that police have options, right, to, instead of bringing a child to juvenile court and being arraigned and creating a record, because that's the deal, right? If you get arraigned, you now have a record. If you can be diverted or go to mediation, it can kind of set a kid right without creating a record. So juvenile court records are confidential, except they're really not, because if whatever you're doing, you're applying for a job with a high security clearance, it's going to come up, right? And on your juvenile record, I always tell the kids, this is what I say to them. I'm like, you don't think about this when you're 14 or 15 or 16, but someday you may apply for a job that has a high security clearance. And if you have a knucklehead thing on your juvenile record, assault and battery, the prospective employer has two candidates, one who doesn't have a juvenile record, one who does. And they're probably going to lean towards the person without the record. Nobody wants to hire somebody who has an anger problem or is going to be a problem employee, right? So not only is there this big push towards mediation and diversion to prevent kids from getting records, I have the authority in certain cases, even if the district attorney's office isn't going to divert, we have judicial diversion now, where we try to, again, keep kids from being arraigned, creating the record, but still put something in place that solves whatever the issue or the problem was. Not bad. Then, if that's not enough, we also have expungement and sealing of records now, much more easy than it ever was before, but you have to stay out of trouble once you have a record for a certain number of years, not get charged with something new. And there's certain offenses for which there's no such thing as diversion or expungement. And I'm talking big, serious, violent felonies or sexual assault charges and things like that. Those aren't subject to diversion or sealing or what have you, okay?
So the police has the authority to say, we've got these programs, so they're a little bit like social workers.
Yep. Oh, I think they would say yes, yeah.
So that's interesting.
Yeah.
I didn't realize where
Yep.
the line is.
And that's kind of, again, back to full circle to the beginning. When I was the assistant district attorney in juvenile court, you realize, you're not here just to prove your case. You have to approach it a little bit like a social worker. I'm a social work judge. I say it all the time. Because that's really what you're trying to do is figure out why, what brought them in, how do we try to set them right, how do we rehabilitate, how do we do not further harm the kid down the road, but also at the same time realize kids sometimes hurt each other. And if you're the victim of a crime, you want something. You have a right. Victims have rights. They should have rights. If we don't have a balanced system of justice, then people will take the law into their own hands, right? Vigilante justice.
So police, they have training in this? They say, okay, we're going to tell you what the young people have these options, and we'd like you to, try to use them at your best discretion.
I'm not, again, I couldn't speak right now to what information is given to the officers. I mean, usually there's each police agency has a particular officer or maybe one or two that tend to go to court and file the charges, right? So it's not if you can picture Pittsfield, you guys obviously have Lee Police down here, there's more than one officer. They don't all go to court and file charges. There's usually one or two that are assigned to do that. So I'm sure if they are aware that there's a diversion program or a mediation program that's available, that would be my best guess. I haven't spoken to the chiefs about it. They all, are highly, I'm sure, aware of the law and the fact that so if you are accused of a misdemeanor, you have a right to a show cause hearing where a police officer and you go before a clerk magistrate to determine if there's probable cause you committed the offense. So again, some of those cases are held at that level. They don't go any further. But nowadays, again, with the mediation programs, the diversion programs, and the program I was just talking about, Shakespeare and Company, the things that we have access to, we try to get kids into those programs without, again, arraigning them, and if it's appropriate. And some cases are too serious and just too complicated, and an arraignment has to happen. Everybody gets an attorney. Even if you're going to diversion, we still appoint you an attorney, just to make sure that you belong in diversion, quite frankly, because stop the presses, but sometimes people are innocent. So they have to, we need an attorney for the child to assess whether diversion is even appropriate. What if, again, their defense is, I didn't do it. Like, I wasn't even there. I'm sorry, you have to go to diversion, though, or mediate. Like, I didn't do it. So that's still an important part of the analysis, we feel, is to appoint counsel, even for cases that might head to diversion. Something else you said, though, that want to come back to it. It'll come back to me. But any other questions? I talk a lot. Yes?
Can someone under 18 be Section 8?
So yes, it hasn't happened in my court, and I find that very interesting. But part of the reason why is that there aren't great resources or places for these kids to go in the Berkshires. And we say this, I'm not saying nothing against the Breen Center or BMC, and that there are very, very few beds available. And so I think sometimes when you have something, people tend to use it. If you're a person under the age of 18 and your family is deathly afraid that you're going to harm yourself, usually harm yourself because of an addiction to drugs or alcohol, whether you're a juvenile, whether you're an adult, your family can petition the court under a particular chapter and section of the law to have you involuntarily committed to treatment. And for folks whose children, whether they're children under the age of 18 or you're my 27-year-old son, there's a lot of parents out there and families that are struggling with the heartache, obviously, of their loved one and having a substance use disorder. And again, whether it's alcohol or what have you, but there's obviously a lot of risk of overdose with fentanyl and opiates and things like that. Please help my child. Please put them into care. They've overdosed twice. If they keep on this, they're going to be gone. They're not going to survive. So in juvenile court, we do Section 35s, we call them. They do them in adult court. It's a high standard of proof to commit someone against their will. And the tough news is that we call the one place in Massachusetts that takes people under the age of 18 who are committed under Section 35, and sometimes the answer is we don't have any beds. So what do we do about that? And we try to figure something out. Keep them safe until a bed opens up, or and these are just tough questions that sometimes keep you at the courthouse till 7 o'clock with the case, with the family, because we don't know where they're going to go yet. Is there something at BMC? Is there something somewhere? Is there just some good alternative? The adult court deals with it as well. Not enough beds for involuntary treatment. So yes, and sometimes mental health commitments as well. More frequent in the adult court. But yeah, so I haven't had them. But my colleagues who sit in courts in Worcester and in Boston do them with some frequency because there are hospitals there that have entire facilities or at least floors that could handle that. So not enough resources is a common, besides not enough attorneys, not enough resources, and I would say in particular for kids. COVID did nobody any favors. There's a couple of silver linings, right? The Zoom was a silver lining. A better schedule, sure, a silver lining. I think we'd all rather it didn't happen, though. And what happened is a lot of kids, obviously, who stopped going to school, when school went back full-time in person, the kids that were really suffering from anxiety, first and foremost, or kids who struggled socially, maybe on the spectrum or what have you, they really, really struggle to get back to school, right? And some of them, they can't. Like their anxiety is too great. They just won't go. It's very difficult to pick somebody up and put them in the car and make them go. And so we spend a lot of time in my court trying to figure out what could motivate a kid to get back into school. The school spend a lot of time trying to figure out what can motivate a child to come back into school as well, or what can we do in the alternative, right? Not everybody has to take the same path to getting their high school diploma, and sometimes home education is the most appropriate route for some kids. But I always say, folks say, well, can't we get them into counseling? Can't we get someone into treatment for this extreme anxiety that they feel? And the answer is there's waiting lists, just not enough therapists, just not enough therapy slots. Therapy doesn't cure everything right away, as it takes time, and so that can be really, really hard for the folks who are trying to address the issue and problem, right? So, yeah. Any other questions?
I'm just curious about when you say some of your slots are 15 to 20 minutes.
Mm-hmm.
Is that usually on Monday on delinquency?
No. That's so when we have an open care and protection case, there are trials. Those are hours and hours and hours. Those I usually do in person. We want to make sure everyone can hear everything, see everybody. If you're on trial and your parental rights are on the line, we want to make sure that you can in real time whisper to your attorney, that's not true, or make sure you ask this. And so we tend to do those trials in person. But there's a lot of things where we're just checking in on the status of something. So it might be like, how are things going, with the drug treatment program? How are things going with school or what have you? Like there's different types of hearings that lend themselves well to a 10 or 15 minute discussion. I will tell you that, and just the way all courts were, in the olden times, the before times, we only ever had 10-minute discussions anyway on a lot of these cases, but we spent a lot of time trying to get everybody into the courtroom from wherever they were in the building. Oh, they went to move their car. Oh, they're in probation. Oh, they're conferencing a case with another attorney. Go get them. And so we would call a case. I'd sit up there, for a while. Where's attorney so-and-so? How come we can't? It would take forever. So then the family would come in and I'd say, okay, what can we do today? And they say, Judge, we all need trial dates. I say, okay, let's set some trial dates. And that's it. That's all we did. It only took, 15 minutes, I'll be honest, to set trial dates. It takes forever because you got 6 calendars. And so it's that type of a case where it lends itself well to a Zoom because we have 15 minutes of solid conversation. And I will tell you this, again, I've evolved as a judge over the past 15 years. And I evolve sometimes because something happens. Something happens in my own court or something happens in somebody else's court. And I say, we got to be more careful. So for example, we're supposed to ask at every hearing, of course, it makes perfect sense. How are the kids doing? Right? Who's seen them last, right? The kids are in foster care or the kids are home. You want to make sure child's counsel, you want to make sure the social worker, you want to make sure the parents are having family time. How are the kids doing and, who has seen them? Is there anything they're struggling with? Are there any needs that they have that aren't being met? They're on a waiting list for counseling. We hear that a lot. But how are they doing school-wise, right? School is such a huge part of every kid's childhood, right? And continuity in where they go to school, if you can picture it, right? I went to the same elementary school, then the same junior high, the same high school. No one ever plucked me out and took me away from my friends and put me somewhere else where I didn't know anybody. And I had to get caught up at whatever they were, and then put me back here or move me to another placement, and I'm in a different school now. It's such a disruption to a kid's educational experience. So you want to make sure that to the extent possible, the kids have educational continuity. And DCF by law, and the social workers do, I think, a pretty good job here of trying, even when kids are placed out of their district in foster care, that make sure that they get back, if it's possible, to their district for school, right? So that they don't miss those, they don't lose those links of the great teacher that they love and the friends that they have, and the normalcy and the sameness of their schools. So check in on those things, right? We're so focused sometimes on how are the parents doing? Are they working on what they're supposed to be working on? Is DCF doing what they're supposed to be doing? That I start most hearings by saying, how are the children? Any worries about their placement? Any worries about their education? Any needs that aren't being addressed? When did you last see them? And that's where we start that discussion. We move on to, what are the barriers to bringing the case to a conclusion, if any? What are the things that need to happen? Are we at a point now where we should set some trial dates, or do we think that we're on a reunification track? And just if we can get a little more work done. A lot of times our Department of Children and Families ask parents to do parenting classes or engage in therapy and get on a wait list, or to be evaluated further, and there's wait lists for that. But it's not impossible, and let's move this case along. There are time standards that we're supposed to complete cases in. And we look at every case individually, and sometimes we are above the curve on those time standards, and sometimes we're way behind because families, that's life. And so, so sorry, yes. Shakespeare, yeah.
My thought, too, about, I'm wondering if you would agree that so many people who finally get their degrees and have the ability to do work as an attorney, there's so much more money to be made with these
big firms? Yes.
Yes, who
Yeah.
are doing
Yeah, and if you, yes, yep, and again, there's I don't judge anybody who says I'd like a nice big salary. That's a nice thing. And when you come out of school with a ton of loans, you want to be able to pay those loans. And I didn't want to pay my loans back in any reasonable period of time. I have paid them back because I've been out for 30 years. But no, so those are definitely considerations, right? So they do have some programs where there is loan forgiveness for people going to the district attorney's office, public defender's office, and I think legal aid. But we rely on so many private attorneys to take cases that it's too bad there's not something there, some kind of, besides like compensation for your work, but then perhaps something about federal loans. It's a great idea. I'll bring it up. But there's nothing for the private attorneys in that realm. And the one that now I remember, so we're lucky that Shakespeare and Company, Barrington Stage, Williams College, the Clark Art have all wanted to work with juvenile court kids. And it used to be if you were charged with something and have a record because you've been arraigned, one of your probationary conditions might be complete the Shakespeare program, complete the Barrington Stage program. Now we pretty much offer our programming to any kid that's at risk. Whether you're a diverted kid, never been arraigned, you have a CRA, or we even offer our program to kids who really liked it, loved it the first time around and just want to do it again, okay? So, and there's kids and you think, oh my gosh, what kid would want to do the Shakespeare program, right? Memorize either all or a portion of a Shakespeare play, so complicated, doesn't make sense at first read or even sometimes second read. I don't know what I'm saying. And somehow there's some part of the brain, I always say, that's triggered and it's also the amazing folks at Shakespeare and Company, the teachers, the director, Kevin Coleman, they magically work with these kids, make them feel important and smart. They give them the most professional costumes, professional lighting, professional sound. And I have to say, we're always nervous as the Shakespeare performance approaches. As you can imagine, the kids get anxious, right? When kids get anxious, they sometimes don't behave. We've had situations where everything seems to be falling completely apart. I say, this is the year, it's going to all, and then somehow magically, it all works. The kids remember their lines. They aren't just reciting them, they're actually acting. We give them swords and they don't hurt anybody else with swords. Shakespeare, again, it's the folks at Shakespeare that work their magic is all I can say. And a probation officer is really committed to it. But we just finished a program like the Williams College. They do a program called LIFT where they assign student mentors from Williams College, they're all just amazing kids, right? They want to work over their January term with a kid from our court to help them do a research project and then present this research project at the graduation, usually with a nice PowerPoint. The Williams College kids have access to all kinds of amazing things up there, 3D printers and the kitchen and the gym and the whatever, and they just always knock it out of the park with these heartwarming presentations. And what we for the kids, everybody benefits. The kids benefit, but also the Williams College kids benefit. So anyway, we're lucky we have that. Yes, yeah. So yes.
I'd be interested to know if you had any, for instance, because you were a woman, that some people think that only men should be judges.
What's funny is that I have honestly, I feel like I've been very lucky, and obviously some of it's your choices you make, but also just luck of the draw. So I've never ever felt, whether when I was an attorney or when I was applying for a judge, that somehow I was not going to be taken seriously because I'm a female or what have you. And I've never felt in court, honestly. I've never felt disrespected by a litigant. I know I've been disrespected plenty, but not because I'm a woman. It's the decision I'm making they don't agree with, I think, that might cause that. So the attorneys I find are equally as respectful. So it's interesting as I know folks out there suffer discrimination and women may in the workforce to some extent, but I have not myself. I couldn't say that I've been held back or experienced it, and yeah.
We need to have Deval Patrick.
What's that?
We need to have Deval Patrick do a team approach.
Yeah. Yeah. So Deval Patrick, I'm very, very grateful to our governor, and we have a great picture. When he left office, all the judges he appointed got together in the State House, and we took a big group picture. I don't know how many people were there, 60, 70. He was governor for a while there, and it's a nice big, diverse group of folks. Yep.
So
Yeah.
I'm going to stop you there, and then if anybody has individual questions that they can come in.
Yeah, so sure. Yeah.
Thank you so much.
Oh, Michelle, thank you so much. Thank you for listening.